All right, good morning. This is the House Judiciary Non-Civil Committee. We're here to consider several propositions this morning. And we will start off with SR 146 and SB 127. And I don't know if Senator Kennedy is here or not. Let me ask Mr. Poston if he's here to come on up. Bert Poston is a DA is the elected DA in the Dalton area and has been working with the author and myself, other members of the committee and council on getting this, based on the last hearings, getting the drafts into a form for a motion. And there have been a couple of changes, nothing earth-shattering, but some tightening to make sure that, as we talked about in the first session, the first meeting on this package, is to make sure that what we're doing is tight and not have the law of unintended consequences kick in later on. So, Mr. Poston, if you want to speak to those changes that we've done.
I'll be glad to, Mr. Chairman. And I'd also say first off that the district attorneys remain supportive of the bill. The changes we feel do clean up a few things and do address some of the issues that were raised at the last hearing. There are three locations, starting on line 2 of SR 146, where tracking the existing statutory language, there was reference to crimes that had been committed or had allegedly been committed. The has been committed has been removed, and the reference is just now to allegedly been committed. And I think that eliminates any kind of constitutional presumption about whether a crime's been committed. It just, as soon as a crime is reported and alleged by a victim, we're going to treat the victim like a victim, and that's all that really matters. So it doesn't change anything substantively. I think it just tightens up that language. Going down to line 14 and 15, there was some language there about the victim being afforded certain additional rights, including but not limited to, and that's been tightened up to just say such victims should be afforded the following specific rights. So that's just a little bit of a cleaner, easier to understand phrase. Right below that on line 16, the words upon request were added after the right, because obviously the right to notice is given upon the victim's request. If the victim doesn't want to be notified of certain hearings, we don't bother them with that. So that language has just been left out by accident. And then moving down to line 48 on page 2 of the resolution, there was some language at the end of subsection C3 that basically said that the General Assembly, when it passes statutes that regulate or expand upon the exercise of these rights, that couldn't violate the Constitution. And I think that language was deemed to be unnecessary because it was stating the obvious that you can't statutorily undermine a constitutional right. So that came out. Then turning to SB 127 on page 2.
Let me ask any questions, members of the committee, on SR 146. Mr. Bodie.
Yes, sir. Thank you for all your hard work. When I looked at the substitute yesterday, I did not see where we were going to add in the language that all parties to the criminal action will be parties to the hearing with the state and the victim. Is there a reason why we didn't put that language in there?
That's in the bill, and I was about to address that if we
Where?
can. In the SB 127 is where that language, part of that language was already in there, and some additional language has been added.
Yes, I read 127 as well, and I wasn't completely comfortable with the language, but I'll let you go through your presentation. We can talk after that.
Okay, thank you. So page 2 of SB 127, starting at line 26, which would be subsection C2B. The language, the first couple lines was already in the bill where it talks about the victim, particularly line 28, the victim shall provide a copy of the motion to the prosecuting attorney and the defendant. That was already in the Senate version of SB 127. What was added below that was the new section 3, or was added to section 3, subsection 3 at the end. The prosecuting attorney and the defendant shall have a right to be present at such hearing. So that was added, I think, to address that concern. And then going from there, the subsection 4, the court's decision on all issue of fact and law raised in the motion of this subsection shall be final and shall not be subject to appeal. That was to address the defense bar's concern, and to do that specifically in statute, so that if there ever was a point in the future where it was felt that some limited right to appeal should be given, that could be done because it's in statute, not in the resolution. Below that, subsection 5 was added, clarifying that this is the only mechanism enforcing the rights in the Constitution. And then down at line 42 to 44, some additional language was added to clarify that this would become effective on January 1st of 2019 if the resolution passes and is adopted by the voters on the November ballot.
Mr. Bodie, did you have follow-up, or you want me to go to somebody else first?
Yes, just one quick follow-up. In line 28, would you be a friendly amendment where it says provide a copy of the motion to the prosecutor, attorney, and the defendant? Would you have any issues with provide a copy of the motion and notice hearing to the prosecutor, attorney, and the defendant? Because a lot of times the criminal defense attorney, receive the motion, but I may not know when the rule nisi is set. So I would like to have that language just to make sure that my criminal defense attorneys know about this. And once you know about it, it's almost quasi that you are going to be there and you've been put on notice of that. So would you have an issue with that?
We certainly wouldn't. I
Okay.
don't think anyone would have any issue with that if that was to be
All right,
done.
let me ask you to go ahead and start drafting that.
Yes,
So that at
sir.
the appropriate time, I can recognize you for the amendment.
Thank you so much.
All right,
Mr.
Ms.
Chair.
Price. I'm sorry, Mr. Sessler.
Hey, Mr. Chairman, appreciate your work on this. This is just a kind of a, sort of a parenthetical question, I guess. What is our process in Georgia if there's a defendant that's concerned there's gonna be retribution against them, not a defendant, I'm sorry, if there's a witness or a victim that's concerned, if they come and testify against the accused, that there's gonna be retribution, do we have a pretty robust system to protect people? Is that something that was contemplated in this, or we would think about moving forward?
There is not a witness protection program at the state level like, say, the federal system would have. So we kind of deal with that more on a case-by-case basis. But there's not any specific statewide system or program that addresses that sort of thing.
Mr. I just raised the question, I'm aware of that. I get that. In the considerations that went into this, I would just share in support of SR 146, I would just share a concern that we consider moving forward if our society changes to a place where people who are rightfully standing as witnesses, victims, witnesses, and that whole camp, if there's maybe something we ought to consider to protect them. I'm
Certainly.
just concerned that moving forward, it may be a harder and harder thing for people to be able to do with respect to their own safety.
Certainly. At the local level, we sometimes have funds that help victims either relocate or do things like that, but there is no specific program, and that could be a good thing.
Any further questions for Mr. Poston? All right, seeing none, we'll address the constitutional amendment first. SR 146, LC 298068S. What is the pleasure of the committee?
Move to pass,
Mr. Setzler moves due pass of SR 146, LC 298068S. Is there a second? Second. There's a second by Ms. Silcox. Are there any amendments? Seeing none, any further discussion? Seeing none, on the gentleman's motion, all those in favor signify by saying aye. Aye. Opposed? The ayes have it, the motion is adopted. We'll move to SB 127, LC 298042S. Is there a motion? Mr. Sussler moves due pass of SB 127, LC 298042S. Is there a second? Second by Mr. Coomer. Are there any amendments, Mr. Bodie?
Yes, there is an amendment. I would like to move for an amendment to line 28. Provide a copy of the motion and hearing notice to the prosecuting attorney and the defendant. So we're adding in the word hearing notice.
And hearing notice. On line 28, Mr. Bodie moves to move an amendment on SB 127, LC 298042S after the word motion. I'm sorry, on line 28. After the word motion, insert the words and hearing notice. Inserting the words and hearing notice after the word motion on line 28. Is there objection to the amendment? Is there objection to the amendment? Hearing none, the amendment's adopted. Are there any further amendments? Seeing none, any further discussion? Seeing none, the underlying motion of do pass, and we'll call it by substitute of SB 127. All in favor say aye. Opposed? The ayes have it. The motion's adopted. Thank you, Mr. Poston. Senator Kennedy, I thought I saw Senator Kennedy.
Yes, sir.
There he is. Thank you very much for your leadership on the issue.
Thank you, Mr. Chairman. I thank all the members of the committee. I appreciate it.
It's our pleasure. It was a good piece of work product. Thank you.
Thank you, sir. Thank you.
Okay, moving on. Is Senator Underman here? Oh, well, do we have, All right, so let's go ahead and do SB 39. Senator Underman is not here. Vice Chairman Reeves has graciously volunteered to walk us through that. Vice Chairman.
Thank you, Mr. Chairman. This bill originally came to us by Senator Underman, and it was a bill that was focusing on the conduct of the pimping and pandering statutes in Georgia law. And the bill, as originally filed and passed by the Senate, made the offense of pimping a felony offense in the first time that for the first offense, and then further, the bill created a new penalty for pandering in your third offense of pandering that would raise to felony level conduct, and it will also create sex offender registration requirements. And so we had a couple of hearings on this, and really talked about the distinction between the efforts that we have put forth in human trafficking and the sex trade versus the criminal activity, and has been recognized as criminal activity in a long time in Georgia, of prostitution and pandering and pimping. And what I did with the bill is, and I had worked with Senator Underman on this, was I took it and looked at what some of her goals were, and rewrote it in a way that I think achieves some of what she was looking for, but I think creates a little bit better balance with drawing that distinction between the sex trafficking versus what would be considered consensual prostitution, which is illegal and should be illegal. So what this bill does essentially, for a first-time offense of pimping, the offense would remain a misdemeanor, but the jail time that would have to be served would increase from 24 hours to 72 hours. And then it goes on further in lines 19 through 21. A second offense of pimping could result in a person receiving a felony charge. So if they've been convicted once, then if they're still at that conduct, then they would then potentially elevate into that felony range. And then if you move down to line 24, 16-6-12 is the pandering statute. So again, the way the bill originally came to us, the third offense of pandering would be a felony offense that would subject a person to the sex offender registry. What we simply did was remove the felony provision and also remove the sex offender registry provisions from that, and we left the offense at a misdemeanor, but for the first offense, you would still serve a minimum of 24 hours in jail. For a second offense, you would serve 72 hours in jail, and for a third or subsequent offense, you would serve 96 hours in jail. So that's what we did on this bill. I'll be happy to answer any questions.
Questions for the subcommittee chair? Mr. Bodie.
Mr. Chair, I really appreciate those changes. It seems like it's more in line with our criminal justice reform. I just want to ask you if you had any issues on line 21, where we are making the second offense a felony, instead of us jumping from 1 to 10, would you oppose having a second offense jump from 1 to 5 and a third or subsequent offense jump to 1 to 10? That way would probably be more in line with your pandering, where we have account 1, 2, and 3.
How about this? I would have no issue with a second or subsequent conviction being a 1 to 5.
Okay.
I have no issue with that amendment.
Okay. And also, Mr. Chairman, Sub-Chairman, would you have an issue on lines, I understand line 25 is 24 hours. Line 28, would you have any issue with kind of more in line with the statute? Because I have never seen 96 hours in a statute, but maybe the second offense can go to 24 hours, and the third offense on line 31 can go to 72 hours.
I would object to that. I mean,
Okay.
I would argue against that. I think that, I mean, all of this is conduct that is certainly, you know, it's illegal, and obviously the point is not to debate that, but I think that a first offense, 24 hours, and then if you still feel that you need to engage in this conduct, that an increased jail time is appropriate. So I would ask that it be kept at where it is.
Cox.
I was just going to say, so appreciate Vice Chairman Reeves' work on this. I think it's critical that we draw a distinction between the sex trafficking statutes and the pimping and pandering statutes, and I think those lines were starting to blur a little bit, so I appreciate his hard work on this.
Mr. Setson.
Thank you, Mr. Chairman. I just want to address Representative Bodie's question about the hours. I do think one thing in this is that I think just as we move forward with criminal justice reform, I think there's value in making offenses that we keep misdemeanor offenses have some meaning to them. I think so often there's this presumption, no, it's a misdemeanor, it's a glorified traffic ticket, and I think we do want to I think we do well as a committee to create offenses that are misdemeanors that do have some jail time like this to them, but we keep them below a felony threshold. I think when we don't do that, I think there's this push that if it's something we're really serious about, I mean, and it's never said this way, but there's this sort of implicit sense that if it's something we're really serious about, we ought to make it a felony. And I think we do well to keep things misdemeanors in certain circumstances, but put some jail time behind them. I think that's Chairman Reeves' approach here. And I think also to the extent I would just say to the committee and those who were interested in the bill that came over from the Senate, I do think that when you look at the elements of pimping, I think people have in their minds, Mr. Chairman, what pimping is. But when you look in the elements and code of what can constitute pimping, there can be a lower threshold of activity that can meet the definition of pimping, that for a first offense would not seem to rise to a felony. I mean, a referral, giving someone a prostitute's business card and making a referral, as it were, if you're a hotel employee, meets the definition of pimping. I think that Chairman Reeves was wanting to make sure that the balance was struck by the things that by definition can represent pimping in our code. There's some balance there, and I would just applaud the chairman in his efforts to do that.
Ms. Price.
Thank you, Mr. Chairman.
Is the button pushed there?
Well, maybe not. Just a practical question regarding what is typical detention, like prior to putting these measures into place? Like, would somebody exceed the 96 hours anyway, or?
Sure, a judge would have the ability to sentence somebody up to 12 months in jail. But what this does is it creates a minimum requirement. This is one of the issues that we had addressed in a previous legislative session. One of the things that we had seen happen was that folks were getting a citation for some of these offenses and then going to municipal court and paying a fine, and therefore there was no record in their criminal information history about it. And so in order to try to create a tracking mechanism so that they have to be booked in and out, we created the minimum of 24 hours to serve so that it achieved that. And it also put a little bit more of a punishment. You know, having to go to jail for a day is certainly much more significant than paying a $250 fine, right? And then walking out. But a judge would have the discretion to sentence up to 12 months in jail if they found that appropriate. But at a minimum, these are just creating the minimum thresholds of what they would have to serve. And so we talked about it in subcommittee, and we felt like an elevated response to second and subsequent offenses was appropriate, considering the nature. And again, as Chairman Setzler said, recognizing the difference between misdemeanor and felony conduct, and wanting to be cautious in going to felony conduct, tried to create more teeth with this, but leaving it at misdemeanor.
Thank you. So currently, typically, people are serving no jail time.
Well, the current law is 24 hours, so right now, according to law, you would have to serve at least 24 hours. A couple years ago, there was no minimum on it, meaning that they may serve, if the judge sentenced them to no time, then they wouldn't serve any time.
And so it's not likely that somebody would serve more than 24 hours under current law.
It would all depend. I mean, I've personally never been involved in a case like this. I had a client that, let me restate that. Never had a client involved in a case like this, so I don't recall seeing that go down in court. I don't know what judges typically are doing on these.
Thank you.
All right, I see no further questions. Is there anyone in the audience who wants to be recognized in opposition to SB 39? Anyone who would like to be recognized in opposition to SB 39? Seeing none, what's the pleasure of the committee? Ms. Silcox moves due pass of SB 39 by substitute LC 298038S. Is there a second? Second by Mr. Coomer. Are there any amendments?
Yes.
Mr. Bodie.
Line 21, I would like to add after the word of, starting with not less than 1 year, no more than 5 years. So essentially, we're changing 10 to 5.
All right, Mr. Bodie proposes an amendment on line 21 to strike 10 and insert 5. Discussion on the amendment. Discussion on the amendment. Is there objection to the amendment? Is there objection to the amendment? Let me express a thought on that. I mean, when you've got a range, the wider the range, the more discretion you have for the judge. So, I mean, if you've got a second, and I'm just thinking out loud here, I mean, the whole idea is to give the judges a good, healthy range, depending on what kind of conviction we're talking about. I know the gentleman, does this on a daily basis. When you're talking about a second, maybe that judge is going to err more on the side of the 1 to 5 as opposed to the 5 to 10. But when you're getting second and subsequent, we could be talking about 4th, 5th, and 6th, and then you're getting into, the point being, you're getting into clearly something more than a second. That one would think intuitively moves them closer to the 10. So we have that graduated, what's effectively a graduated scale.
And And Mr. Chairman, I have no issues with that. Like I stated earlier, what I really would like to have, if we had a first being, a first offense we already have, but the second or subsequent offense could be 1 to 5, or the second offense could be 1 to 5, and a third or subsequent offense can be 1 to 10. So that way, we're still within your graduated range. That way, prosecutors and defense attorneys know, okay, the max on this second offense is 5, but the max on the third or fourth offense will be the 10. And so it still gives us the same graduation that we have with pandering, because under pandering we have a 1, and then we have a second, and then we have a third or subsequent, which gives that individual 96 hours. So I think it'll be more consistent with our pandering statute that we have today.
Let me hear from the vice chair, and then I'm going to ask the prosecutors for their opinion.
I mean, I have thinking about it, when we start thinking in severe repeat offenders, I do think that certainly the 10-year range could be appropriate. I have no issue with a second offense being 1 to 5, and then a third subsequent being 1 to 10, if that's what the committee feels is the easiest way to do it.
Okay. Mr. Scanalakis or any of your colleagues, do you have any thoughts you want to express on that?
No, sir, whatever the will of the committee is fine with us.
Okay. So, Mr. Bodie, do you want to
I would
restate your?
Yeah, withdraw and restate. So what I
Okay.
would do, Mr. Chairman, is that we will make line 21 the second of a conviction, so we would need to mark through line 20, so we don't need subsequent. So we'll mark through or subsequent and just say second conviction. And then on line 21, we'll say not less than 1 year, no more than 5 years. And then we will have to create a separate section.
You mean 10?
Ten,
You mean replace 10 with 5?
replace 10 with 5, exactly, Vice Chair. And then what we would need to do is state that provided upon a third of subsequent conviction, he or she shall be guilty of a felony, shall be punished by a term of imprisonment not less than 1 year, no more than 10 years.
All right, so effectively, I mean, I think what we can do, council, is just, I think we'll maybe just express the intent and then leave it to council to go ahead and draft accordingly, that essentially Mr. Bodie's amendment will be to, on a second conviction, 1 to 5, not less than 5, not less than 1, no more than 5, and a third or subsequent, not less than 1, no more than 10.
Exactly,
Okay,
Mr. Chair. Thank
okay.
you.
Further discussion on the amendment? Further discussion on the amendment? All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed? The ayes have, and the motion is adopted. Are there any further amendments? Representative Bodie, 2 for 2 today.
I think my criminal defense lawyers are liking me today.
I see no further amendments, no further discussion. All in favor of the underlying motion by substitute of SB 39 as incorporating the Bodie amendment signify by saying aye.
Aye.
Opposed? The ayes have, and the motion is adopted. Let's move to SB 335. This is, recall, Senator Unerman's bill that mirrors Representative Silcox's bill, the underlying bill, correct?
We have it.
Part of it is, and then we're adding, we've added Representative Setzler's, Chairman Setzler's House Bill 1006, which was which addresses the issue that Representative Chandler sought to address in her House Bill 32, which has been pending this term, and it's an issue that we've taken a crack at several times. Recall that in our last meeting on this particular bill with the incorporated language from 1006, that was a meeting we had in, I think, in one of the 15 rooms, 415 or 515. Mr. Setzler walked us through his approach on it. It's a bifurcated approach on SB 335. What I want to do is, as opposed to getting into, we've been through this before, what I want to do is ask Chairman Setzler any changes that have occurred in between that substitute that we heard at the last meeting where he addressed his 1006 language and this new substitute, and I'll recognize him for that purpose now. me just press the,
Thank you, Mr. Chairman. The proposal today on Senate Bill 335 is LC version 298077 ERS, and we have incorporated some questions raised by Chairman Ballinger in the previous full committee, and some questions that came back from the prosecution community that would have clarified this and tightened up some things that, and I appreciate their efforts on this. What we've done here, Mr. Chairman, is there was a question, and just broadly for those, and I'll just very quickly say this creates a circumstance where in the cases of students and teachers in schools, if there's sexual contact between teachers and students, or sexual contact between people in a probation setting or a custody setting, currently there's a narrowing effect in the law that if the person does not have supervisory or disciplinary authority over the individual, the person has zero criminal responsibility for sexual contact. So what this bill does is it broadens that dramatically by bringing, basically, if you take the school setting, any employee or agent in the school now would be subject to criminal responsibility for sexual contact with kids. So in creating a vast broadening effect, we also created tiers where the severity of the sexual contact was tiered out, first degree and second degree. First degree, in essence, being intercourse and the like. Second degree being touching and the like. So that as we broaden the people that are included in this, we also created a tiering effect. Some questions that came back from the prosecution community were the definition of supervisory and disciplinary authority. Tracking policy-wise with the Hammond case, which is the current Supreme Court case that deals with this very question, we took the thinking of Hammond where, and that's captured here, Mr. Chairman, on lines, I'll give you the on line 66 of the bill and also on line earlier. So supervisory authority is defined there. Disciplinary authority is defined on line 42. So supervisory authority, which is a circumstance which, again, as we tier this, creates a more severe treatment. The thinking behind this whole section, 16-6-5.1, in the first place, was when people have supervisory or disciplinary authority of another, the idea of consent is invalidated because they can't validly consent by virtue of their relationship to the perpetrator. In this bill, as we broadened it beyond just those that have supervisory or disciplinary authority, we include people who do not have supervisory or disciplinary authority and still make it violations in which consent is not a defense. So it is a dramatic broadening of this statute. But in doing so, that's where we felt like we needed to tier this. And also the question of one of the prosecutors, we've defined disciplinary and supervisory. And if it pleases the chair, I can walk through those definitions a little bit. Okay. Supervisory means direct control, oversight, or management. As the Hammond case spoke to, if you've got a school secretary who's just has an administrative function, they might have responsibility over students who work in the office, or if they're an assistant cheerleading coach, as one particular individual does, responsibility over their cheerleading squad, but do not have supervisory responsibility over people in classes throughout the school or over a football player. So this tracks that essence from the case. And disciplinary authority, as it was fleshed out in Hammond, is not anybody who can write a discipline slip. There could be a janitor that could see someone breaking the rules and make a disciplinary referral. The disciplinary definition would be somebody who can make determinations of what the outcome is. A teacher could say, hey, you're staying after school, you're going to do Saturday school, whatever. Teachers of students can make disciplinary determinations. Principals can make those determinations. So as it's crafted under the substitute, it's either disciplinary authority or supervisory authority. Either could get you in. What this means is if schools give teachers disciplinary authority to make determinations to any student, even not their own, they might have disciplinary authority over a student for which they did not have supervisory authority. So we wanted to create really the structure of Hammond and put that in the statute here, and that's what the substitute incorporates, Mr. Chair. Also, Mr. Chair, there was a question that the Prosecuting Attorney's Council brought to us on ORs. As it had been crafted, it could have been a sentence or a fine. This ensures that it's both a sentence and a crime. doesn't mandate any amount of money, but it's both a sentence and a crime, so there couldn't be a sort of a chaotic effect of how that works.
A sentence and a fine.
That's correct.
Right.
So, and then lastly, Mr. Chairman, another thing brought by the prosecution community, there was a concern. We had language in here that said, a person that has sexual contact with a person over 16 years of age for which consent was granted. It's not it wasn't an issue of guilt innocence, but they could introduce that for purposes of sentencing. We pulled that out. It just, in talking to our own counsel, it would have been sort of not in step with our criminal code to have that in there. So we believe juries, if consent's demonstrated, that's considered as a mitigating factor, has nothing to do with guilt innocence. It just, we in the previous version said, if consent's demonstrated, it may be considered by the courts. It was permissive language anyway. And we just pulled that out of the substitute. Because it was only permissive, it created some inconsistencies across our criminal code and felt like it's best just coming out, Mr.
Ms. Silcox.
Okay, so looking at page 5, line 165, is that where you're talking about?
No, ma'am.
Okay.
What 165 refers to is the sex offender registry and mandatory sentencing, split sentencing provisions. If you're subject to 17-10-6.2, on a 1 to 10 offense, for example, you've got to be sentenced to at least 1 year of jail and 1 year of probation. So that's what 17-10-6-2 does. So what this does is it also, by invoking that, the way the bill operates, that also applies to sex offender registry. So really more significantly, if a person, unless the state can show by preponderance of the evidence the person is engaged in a similar offense or similar effort, and again, introduces the consent piece, that is a narrow gate by which somebody who had sexual intercourse with a person could escape the sex offender registry. And the thinking being, take a teacher, for example. They made no attempt to have sexual contact with any other student. Or they had no other sexual contact with any other student. They made no other attempts. And the one student that they were caught having sex with, it was demonstrated was consensual. Is that person a sexual predator by definition? And the thinking was that person's exercising very bad judgment, for which they're getting a 1 to 25 felony. Or if they have no relationship and authority with the student, a 1 to 10 felony. But because of that, should they be deemed a sexual predator that we treat like a child molester? And as we work this out with PAC and back and forth with the defense community and PAC and others, it's my contention from a policy perspective that a 29-year-old coach that has sex with an 18-year-old student needs to go to jail. But it doesn't make him a sexual predator.
I appreciate that. And then just a follow-up question. So you think that community coaches, for example, would fall under the supervisory authority bucket?
Yes, in fact, if you look at this, a community coach right now is, and I don't want to sound crass to the public, as it stands today, a community coach is not a teacher. They're simply an agent of the school. Community coaches under our current law can have sex with as many students in high school as they want to that are over the age of 16. So what this does is if a community coach is over a specific team, they're an agent of the school, they have responsibility for that team. If they were to have sexual contact or if they were to have intercourse with one of their students, it's a 1 to 25 felony because of their authority.
Mr. Bodie.
I wanted to say, Mr. Chairman, Setzler, we appreciate you really breaking this down. I know we had plenty of conversations, and I think your tiered effect that you have is going to make this a more plausible for judges. So I really appreciate what you have done between lines 104 up until 127. Now I realize line 128 we get into the first degree, but I think that's critical that sometimes with the having to file or having to go on the sex offender registry can really hamper someone for a long amount of time. And I appreciate the chair, Chairman Gola, years ago implemented a little bit more leeway for judges on when a person can come off or come on the sexual registry, but it's still very difficult to get out, which is understandable in certain situations. But in lines 110 through 113, essentially your secretary or assistant cheerleading coach language comes into play here. That would be a situation where if assistant cheerleading coach had some type of sexual contact with a football player, that's where she does not necessarily have any direct disciplinary supervision, but she is someone in the school system. Would that be a correct synopsis?
That's correct. Yeah,
Okay.
Yeah, as we discussed with Chairman Ballinger and others, if you have a person that's say a community, whether it's a secretary or say it's a community coach that comes in, they're 25 years old, they used to cheerlead in college, and they're a community coach for the cheerleading team, and they're involved in sexual contact with some student, in marching band, or completely unrelated to them. It's not intercourse; it's just touching. That what this creates is, whereas today it's completely not criminalized to do that, this creates a high and aggravated misdemeanor to do that. So what we have, and as I was talking to some of the representatives of the school administrators, this bill creates clarity. If you are an adult in our school system, whether you're an employee of any kind, bus driver, lunchroom lady, whatever, or volunteer of any kind in an agency capacity, you touch a student, you're going to jail.
Okay.
This bill gives us that. But it also recognizes if you have no relation to the student, they're only in the school, and you simply touch the student, it's a high and aggravated misdemeanor. It's not a 1 to 25 felony. So,
Thank you.
All right. See nothing further. Is there anyone in the audience who would like to be heard in opposition to the substitute to SB 335? Is there anyone in the audience in opposition to SB 335, the substitute that we have before us, who would like to be heard? Seeing none, what is the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of SB 335 LC 29 8077 ERS. Is there a second? There is a second by Ms. Silcox. Are there any amendments? Are there any proposed amendments? Seeing none, any further discussion? Seeing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. Thank you, Chairman Setzler. Members of the committee, we've, before we take up 315, and we will, right now it's, I've got it at just before 11, so we're going to take it up. We are not going to meet this afternoon. That time block was held as a placeholder, frankly, in case things bogged down this morning. Obviously, they have not. I want to congratulate the committee. I know not everybody's here, but I just wanted to congratulate the committee. This is the legislation that we've passed this morning is exceedingly important and is a great example of the type of process that we have in this committee. Every single one of them are. They're very serious matters where we've taken our time and we have really struck a balance in terms of our approach. We've taken input from the prosecution side, from the defense side, obviously from other interested parties, and in making sure that we preserve judicial discretion, but are also reflecting the prevailing will of the people in this state. And I think in striking that balance, we've got good, strong, or potentially good, strong law, assuming that it makes it through the process. And I just want to congratulate the members of the committee this morning from both sides of the aisle for that, for their input, their feedback, their collaborative approach. I think we're doing some really good work here. So with that, let me, I know Senator Thompson is not here. My understanding is Representative Coomer will present on his behalf. Is that a correct statement? Or am I completely on? All right. Just want to make sure. I don't want to be volunteering you if you haven't already volunteered. Very well. So Representative Coomer is going to speak to SB 315, walk us through that process. Then what I'll do is ask him to go ahead and give us a brief overview of the bill. I'm going to go ahead and call on the subcommittee chair to give the subcommittee report. Then we'll go to questions from there. It's the chair's intent, assuming that the committee moves organically in that direction to head toward a motion and closure on the bill before noon. But we'll see how the process goes over the next little while. Representative Coomer.
Thank you, Mr. Chairman. Excuse me. Senate Bill 315 is a bill that is designed to really close a loophole in the existing computer crimes code section in Georgia. Essentially, what the bill does is makes it a crime to intentionally access a computer or computer network with knowledge that the access is without authority of the person who has the ability to give access or to grant authority for access. What we are trying to capture really, and if I can give an example, maybe it help to explain it best, we may have a situation where sophisticated network of people or maybe one person has gained access or control of a computer system and then uses that computer system to do harm or simply to otherwise violate the law that exists now. But that sophisticated actor may also have gained access to 100 other computer systems and is just sitting silently inside those computer systems, maybe watching what's going on or maybe just passively existing there and waiting for an opportunity to do something at a later date. That would not be against the law under current code. So this bill is really designed to capture that activity of the sort of lying in wait, sophisticated computer criminal. And the bill has had a lot of debate and discussion and has made substantial changes to the bill through this process. One of the things that we've really focused on are well, two things. One is the intent level required by the bill for a person to be found guilty of a criminal act, and secondly, we've spent a lot of time focused on the exceptions to the bill or to the underlying statute. So I would point out also that 46 other states already have this law or a very similar law on the books. So we're not really charting new territory here. And most notably, the state of California, which I guess most of us recognize as kind of the birthplace of big data and a lot of data innovation in the United States and around the world, also has a very similar statute. And so I feel very comfortable we've reached a right balance in this bill. And with that, I can answer questions or sit silently.
Let me recognize Subcommittee Chair Setzler for his report, and then we'll get some questions from members of the committee.
Thank you, Mr. Chairman. As you well know, and for those who may not, I'll highlight it. There's been significant discussion about this since being assigned to the Setzler Subcommittee. I would alert people there was an interest in making this new provision comport with OCGA 16-9-93, which is our existing code section dealing with computer crimes. That was passed back in the 90s. There's been a lot of stability in that law. I think it was done in a really impressively complete way given the changes in technology since then. And one thing we've sought to do is to make sure that this is consistent with that. We don't create elements and a structure to this that's just inconsistent with our existing computer crimes law. So that was one thing we wanted to do. And all stakeholders have been very accommodating in that. I will tell you, too, to Whip Coomer's point earlier, once we got the lines 12 through 14 sort of set, where there was a knowledge element, there was an intentionality element to it, that really the exemptions has been what we've tried to look at. One thing, Mr. Chairman, we were not interested in is having everybody that came running to room 406 with their own carve-out, get a carve-out. We wanted to create that balance, but recognizing that we needed to, line 15 says this subsection shall not apply to. So you've got exemptions that if proved by preponderance of the evidence, this whole criminal statute doesn't apply to you. So it's when you think about the way this is constructed, we even had some businesses that kind of tripped in their own shoelaces, I think. They came to us saying, they were concerned about how they could be exposed to this statute. And they said, well, this same household, and some of these other things are very broad exemptions. And if we pause and say, yeah, these are broad exemptions, there's a lot of, I think the author was intending to create circumstances where members of the same household, even if they're not blood relatives, they live together, there's an exemption for people who share living space, perhaps share computers together. So I think there was a recognition that exemptions needed to be appropriate, if anything, erring on the side of breadth, to make sure that it's not capturing people that would be unintended. I think the whip and the author, Senator Thompson, even the Attorney General's office, who recognizes that we're a center of financial technology, that we need to have a statute like this, that putting relatively generous exemptions in this was the appropriate way forward, Mr. Chairman. I think that's what you see here in the substitute.
Questions for the House sponsor or the subcommittee chair? Ms. Price?
16. That one works.
Okay.
Thank you. Having just seen the letter from IBM, I'm just digesting that, but my concerns are something that new that has appeared on this, lines 40 and 41, because it uses a term, authorized computer user, that I don't know that's been defined unless it was elsewhere in the statute, but lines 40 and 41 are also a little vague to me in terms of how could you be authorized but then denied service? It would seem like then you would be unauthorized.
Mr. Chairman. Lines 27 through 41 address venue. And what we're trying to do is hammer down that if you're a computer user, and for example, if someone came in and hacked your computer and denied you access to your own computer, that where you're physically located would be venue for which you could file that. We wouldn't have to track them down if the actor was across the country. You wouldn't have to go to Arizona, for example, to have venue. Venue would, it clarifies that venue would be in your home county. Likewise, if someone came in and interrupted your access to the internet or to a network or a cloud-based application, that the county in which you, the authorized user, were located was definitively venue for that case. That's all that 40 and 41 does. Only deals with venue.
And I appreciate the distinction between the venue and the person, but again, is anywhere authorized user defined?
Well, again, and thank the lady for the question. This code section that we're addressing here in 16993, unauthorized computer access. So as long as you're not a person that is guilty of unauthorized computer access, you're an authorized computer user. And I think the intention was to use the kind of the plain term in doing that. The council may be able to add some.
Definition of without authority. So you have, if you're not without authority, you're with authority.
Okay, thank you.
I mean, this language also came from the Attorney General's office. It's involved in the prosecution of it. As much headache as it's going through the process.
Because in Representative Price, if you notice, any person convicted unauthorized computer access, that's on 12, on 2122. I think you authorized computer user, I think in the plain meaning is, I think the subcommittee certainly believed it was clear. If you've got suggestions for a definition and can make the compelling case, I think it's the chair's, certainly the chair's decision.
I just want an authorized user to be clearly defined.
Thank you, Mr. Chairman.
I'm sorry, counsel, did you want to?
I was suggesting if you look at 16992, it might help.
Okay, I started at 93.
Let me recognize Mr. Coomer, I think wanted to make a comment on the previous dialogue.
Thank you, Mr. Chairman. Just as to the second page of the bill, I would point out that this venue provision does not apply only to unauthorized computer access, the first page of the bill. It also applies to the rest of the offenses that are enumerated in 16-9-93. So I think that's where there's some confusion, because the other offenses do address denial of service or interruption of service. So that language that you see on lines 40 and 41 would not apply necessarily to the language that starts on line 12. It would apply, however, to the language in 16-9-93 that relates to other computer crimes that have, as part of their, the components of those crimes that include denial of service and interruption of service. So I understand why there's some confusion on that, but hopefully that helps explain.
Ms. Ms. Dickerson, did you? Okay. Mr. Bodie?
Yes, thank you, Mr. Chairman. Whip Coomer, thank you for working with the Senate sponsor. It's just a couple proposed amendments that I want to kind of lay out right now and vote upon a little bit later at the appropriate time. But I do feel like on line 13, I understand I've actually spoken with counsel. I feel like in the abundance of caution, and we have to realize that judges, defense attorneys, and prosecutors are going to be looking at this statute in real time. I feel like after the word on line 13, without authority, I feel like we do need to add the language and intent to commit an unlawful act, because what we don't want to have is, I understand that if we look at the background of the statute, we jump around to get the intent. We want to make sure that this is indeed an unlawful act that's being committed. And so I would like to have that verbiage in there and not just go with the implicit meaning of that the person that does this is acting unlawful. Also on line 19, I feel like on unauthorized computer access that we do need to add, for the purposes of this section, legitimate business activity includes acts committed by a lawfully employed individual which are reasonably necessary to the performance of his or her work assignment. Because what we don't want to have is individuals that are working, and this is a legitimate business activity, to be found in violation of the statute. And the last concern that I have is, I appreciate us adding in the cyber security active defense measures in line 18. However, I feel like after line 20, section D, we need to have a section F. And this is probably one of the most important amendments that we need to have. Persons who report vulnerabilities to the vendor or vulnerable party freely in writing. What we don't want to have is a vendor that sees issues or sees some type of violation not be able to report that violation to the person that is potentially the victim. And I think that's very important in protecting those entities, because we don't want to have a chilling effect on someone that's want to put another person or agency on stance through their research or through any type of research that something wrong or some type of violation is occurring to their database or to that system. So I think that's very important that we have that language in there.
Thank you. Let me ask a quick question. Was there a thought, and this is either to the House sponsor or the subcommittee chair or anyone else who cares to respond to it, was there a thought on tightening legitimate business activity, relating it back to, on line 17, relating it back to the ownership of the computer, service of the computer, just some sort of relationship back, so that it tightens up the potential, maybe not quite making legitimate business activity as broad? If you've covered that already, I apologize.
No, I think that is in fact a good policy debate that we can have. My intent, and I think the subcommittee chair's intent, and I don't mean he's here, he can speak for himself, but my intent certainly was to make the language have a broader application insensitivity to the folks who came to the committee and said, you're going to inadvertently catch us in our legitimate activities and make us criminals. And so, in fact, in some of the research I did, I looked at the California statute. The California statute's actually narrower in scope with regard to its exception. In fact, I have the language right here. It says that its exception says that the crime does not apply to punish any acts which are committed by a person within the scope of his or her lawful employment. I think that's significantly different in the sense that the folks I've heard from, there are a lot of independent, self-employed folks or people who do this on the side who are concerned about being caught in this. So under the California statute, they've actually got to have an employer who puts them to work doing this. In our statute, a person can go to court and say, hey, I was doing my legitimate business activity, either self-employed or even on the side, and so it gives them a broader array of defenses to bring into court. That's also my reply to Representative Bodie's suggestion about adding language to subsection 2B with regard to legitimate business activities and narrowing that language. I think if you narrow it, you lose the balance that we struck in creating a defined crime and then giving specific exceptions that are broad enough to give people for lack of a better term, a get out of jail card when they can show that they were doing something legitimate and not doing something, as one of our prior witnesses during subcommittee said, they're not black hats, they're white hats.
Well, I mean, that's what needs to be fleshed out a little bit. And I mean, legitimate business activity, I mean, I'm thinking about my own company's computer, and I work for a major company, and I mean, the legitimate business activity, well, we can't have that, and I'm not saying the gentleman is saying this, but we obviously can't have that as an eye of the beholder determination. It has to be, well, I'm doing something that's on, white hat, the forces of good and not evil. And that may very well be true in the minds of most people, but that ends up being a very fact-specific analysis depending on what they're doing, to what machine. And I understand there are people out there who have acted as independent, independent forces, independent parties that have gone ahead and exposed weaknesses in various systems in our country and the world. I understand that, but the question is, for every one of those that may be a true white hat, you could go ahead and have a situation where there may be an individual who is not, but therefore could claim it's legitimate business activity. That's a factual issue, I get it. But it seems to me that we'd want to have the statute be narrower than that and not have that eye of the beholder determination, because as a practical matter, the enforcement is a governmental function, not by some independent consultant who is trying to do good and really straight face is trying to do good. But that's not really their role, and I would invite reaction to that.
Yes, sir. I think you hit on the key, which is this is going to be a fact-specific question that's determined by a trier of fact and reaching a conclusion as to whether or not the activity which is claimed to be legitimate business activity is or isn't. By further extension, I mean, I guess you could actually take out this exception entirely, because in Georgia law, you always have the defense of justification. And that's really what these folks are talking about. They're saying, well, we should, as a matter of public policy, we shouldn't be captured in this crime because we're doing something that benefits society. We're engaging in an activity that is justified, even if it's illegal. It's justified, and therefore I have a defense. So I think you get to the same result either way. I think that for the comfort of the folks who do this professionally and who are actively engaged in this on many different sides, academically, business activities and so forth, having this line 17 in the bill gives them a level of comfort that they wouldn't otherwise have with the bill. And I'm not saying they love it. There certainly are people who still are not really happy with it. But I do think it essentially applies justification specifically to this bill in a way that you wouldn't have it if you took line B out, or if you narrowed it in a way that sort of has us making the decision of what is legitimate and not, as opposed to having a trier of fact make that decision.
Okay, and that does answer my question. That I mean, while it does clearly present a broader context of a defense, legitimate business activity. Well, you could argue you can drive a truck through that conceivably. At the end of the day, if it's not truly legitimate, the jury's going to go ahead and make that determination as a practical matter anyway. That's fair enough. Let me come down here. Ms. Gonzalez.
Thank you, Mr. Chairman. If I can just speak a moment to something that you just brought up that triggered something in my head, Representative Comer, when you said that this would be left as a question of the trier of fact. And so I would think that in that scenario, couldn't that then lead to a chilling effect where individuals who don't want to take the risk of being taken to court on this just decide, you know what, then I'm not going to do it, because that trier of fact might not know exactly what the parameters of my legitimate business activity would be, and I don't want to go through litigation for this. Couldn't you see the other side of where they say, well, if I'm going to subject myself to that risk, maybe I don't need to do this at all?
Yeah, I don't see the problem with that. I mean, if we want to chill bad activity, we want to keep bad actors from acting. So I think this bill does keep the bad actors from acting. I think it provides sufficient opportunity for a defense. And ultimately, I do trust the criminal justice system in the state of Georgia. I don't expect every judge to be an expert in this field, but I do expect that when this comes up, every judge and jury can take testimony from those who are experts, who will come in and say, you know, X, Y, and Z are legitimate activities, and you know, defendant A was engaged in activity X, therefore it's legitimate. Please don't find him guilty. And I think judges and frankly DAs in determining whether to prosecute a case are going to be asking those questions. I have complete comfort with the ability of our system to take care of those issues. And the members who've served with me on this committee for a while know that I don't have complete comfort with everything when it comes to the criminal justice system. But I think in this case, I think we're giving them the framework to do it correctly and protect victims of these crimes as well.
Ms. Gonzalez, are you done? Yes. Okay, Mr. Bodie, and then to Ms. Silcox.
Whip Kumar, I definitely appreciate your approach. However, I feel like even if we put the language in there for purposes of this session, a legitimate business activity includes acts committed by a lawfully employed individual which are reasonably necessary to the performance of his or her work assignment. It protects the employee in a whole nother way, because on its face, if we have an individual that's being indicted, say they work for a company that is saying that, okay, we're going to do legitimate research for Google, but that employer has a whole different mindset or purpose on that research, this bill or this section will protect that innocent employer. And it could be almost like an innocent employer clause if the company itself is indicted for wrongful cyber crimes, cybersecurity crimes. So that way we want to actually protect someone that's lawfully within their duties, doing their day job, and on its face, it doesn't look like they're doing anything illegal, to be able to do their day jobs without having any type of notion that I'm doing my job the way I'm supposed to be doing my job, but I'm not going to be convicted of something I did not know the higher-ups were doing.
Well, I think ultimately you get to, and let me say this by contrast again to the California statute. The California statute, which has been in place for some time, only requires that a person knowingly and without permission access a computer or computer system, computer network. We've drafted this bill in such a way that it requires, in two different ways, it requires specific intent. You have to intentionally access the computer, and you have to have specific knowledge that the access is without authority. So you don't even meet those two criteria in the example that you've given. Again, the balance we're trying to strike is protecting people who need protection and giving an exemption to the criminal statute for people who are engaged in what we are deeming as legitimate activity, whether that's a family activity, a business activity, or other activity. I think when you start adding additional little carve-outs to the exemptions, you'll lose the balance that we've struck through the subcommittee process, and frankly, the balance that we now have with interested members of the community who in fact, IBM's got their letter in here dated yesterday, but I've been told from yesterday to today they don't have a problem with the bill. They're not, and I don't have anything in writing saying they're supporting it, but I understand they are withdrawing that particular objection or that series of objections. And that's because we made an additional change from yesterday to this subcommittee substitute, or this committee substitute today, that had to do with offensive countermeasures. So that language came out, and again, at every step, I'll just give you a little more history in case you don't know this. The bill was originally signed to another committee in the House. I specifically asked that the bill be assigned to this committee because I knew this committee would give it a proper vetting, that we would get a real review of the bill, and we'd get a better bill out of this committee than we would any other committee. That's why it's here. So I don't want you to think that I'm just saying no to every suggestion because I don't want any changes to my bill. I've been welcome to every change, and what I want to do is get a bill that everybody acknowledges, whether you vote for it or not, you at least acknowledge it's not doing undue harm, and it's not providing unnecessary exemptions for people who really don't need it.
Call on Ms. Silcox.
Thank you, Mr. Chairman. And to Representative Bodie's question, I guess I would say that I agree with Whip Coomer that I do think that this legitimate business activity is better because it provides more flexibility. I know a lot of my constituents own small businesses, for example, and they don't have in-house IT capabilities, and so it wouldn't be necessarily their employees, but it would be subcontractors or other people that they employ that may not be under their supervision, but that are actually working on their computers. So I think that this is critical, I think, in maintaining a balance. If this went to a jury, the trier of fact, I do think that they would be able to determine if this person was conducting a legitimate business activity or not. So I think this is the most important line of the bill, and I think it should remain the way it is, as Whip Coomer expressed. I think it's a great piece of work.
Vice Chair.
Thank you, Mr. Chairman. I know we're jumping around a little bit, but I wanted to go back, Representative Bodie, to the first. You had talked about your 3 amendments, and we've kind of had discussion centered around that. The first amendment that you want to propose, I believe you wanted to add after on line 13, after without authority, something to the effect of, and with intention to commit an unlawful act. And I think that that's the intention to commit an unlawful act, such as downloading information or manipulating information. That's what's already covered under the existing computer invasion, computer fraud statute. But that what makes this the conduct that we're contemplating here is by this bill made criminal without an additional unlawful act. Does that make sense?
And I definitely see you coming, Vice Chair. I feel like in this particular, I'm sorry, Mr. Chair. I feel like in this particular instance, I would want to have a bill that's all-encompassing, where we don't necessarily have to jump to another existing bill where a judge, a jury, a prosecutor, and a criminal defense attorney can see that. Also, I want to put more onus on the prosecution to be able to prove that additional element of unlawful act. That way we can kind of have a situation where the prosecution on their face can say, okay, this may have happened as far as without authority, but was that without authority, did they commit some unlawful act as well?
I think that's the whole point of the bill, though. I mean, it would be like describing the difference between an assault and an aggravated assault. An aggravated assault has more elements and more to be proven, and is more serious than assault. It's also a felony, and assault's a misdemeanor. The other statute, the other computer fraud statute, involves manipulating or downloading information, which is an additional acts, and it is also a higher penalized crime than this, which is a misdemeanor. So I think that extra act that you're talking about is what separates this from the other types of computer crimes. And so my opinion is that I think it would defeat the purpose of I think adding that in would defeat the purpose of the bill if we required some kind of additional unlawful act. That's my take on it. So.
Mr. Setzler.
Thank you, Mr. Chairman. I want to address, if I could, Representative Bodie's 3 issues, and I want to. My goal is not to talk at him, but to sort of see the kind of the substance of what, in essence, we're doing. I think Vice Chairman Reeves alluded to that. You should have a copy of 16-9-93, and at the risk of taking too much time to go through this, I wanted to, if I could direct you there. On the second page of that, there's computer invasion of privacy, which is subsection 3. If you look at on line 2 of that crime, intention of examining any, and it lists a whole series of things. So that you have an intentional element there, and then you have on line 3, with knowledge that such examination was without authority. Okay, you can kind of bracket those. Computer invasion of privacy is a felony offense under Georgia law today. It's been that way since the 90s. So I guess to put a finer point on what Vice Chairman Reeves referred to is, this 315 does not seek to create a circumstance where you're intentionally accessing, knowledge you don't have authority, and then going in with an intention to commit another crime. That's, as Vice Chairman Reeves said, that's done here, okay? This creates a circumstance where people who have, with intention, access, they know they're not supposed to be on that system, and they go in and they hang out there. Oftentimes hackers will go into a system and they will get into the system and they'll sit real still and sit dormant. Now, they may be watching things, they may be looking at things, but from the standpoint of being able to prove they're downloading data, getting personal identifiable or financial information, that's a different thing that's already covered under current code. What 315 does is for people who intentionally access a system, they know they don't have authorization to do it, and they sit there and they sit real still. That's what we're creating this misdemeanor offense for, because there are many cases where we know they know they're not authorized, and we know they accessed it with that knowledge. But the reason we're stepping this down from the felony, which treats the things you're describing, is that getting onto that system knowingly or intentionally, and knowing that you don't have authorization to be there, that's the misdemeanor that's seeking to create. Because we know that's the nature of most of this, is that they show up, they put a presence on the network, on the computer, and they sit real still, sometimes to disguise when they actually enter the network, or sit there dormant, watch things in ways that are hard to kind of define. That's the purpose of the bill, is not to address the language you've highlighted in this ACLU letter, but because those kinds of things are contemplated elsewhere as felonies. So this lower threshold is one where the element is knowledge you don't have access and you're intentionally there. It's a different purpose, I think, to what Vice Chairman Reeves said. So as we fleshed out the elements very carefully on this, lines 12 through 14, intentionally accesses with knowledge that it's without authorization. Those two things, that's the thing that's being considered here. So there's really no language to fix in lines 12 through 14, because the thing that we're talking about is what's in line 12 through 14. So if you've got another bill you want to drop that addresses a higher level of behavior and maybe address that, I get it. But the reason the underlying bill is what 12 through 14 is. And I just wanted to say, to that point, perhaps the debate, Mr. Chairman's around, the exemptions. I don't want to I know the chair doesn't want me to give a monologue, but I do think the access to computer network for legitimate business activity, I don't think there's anything you list below in the highlighted text that's not included in that definition of legitimate business activity. In fact, the letter that you reference here had a qualifier that's been removed from paragraph B anyway. Paragraph B does not have cybersecurity, active defense, and countermeasure. That was taken out specifically because when you put a further qualifier in there, even though it doesn't have a limiting effect, it was seen as coloring the broadness of legitimate business activity. That's why it was moved out. So legitimate business activity didn't have to be defined by cybersecurity measures or lawful employees. As soon as you start to define those, it creates this circumstance, well, I'm not defined. Does that color me out of it somehow? That's why it was pulled out, and it is simply legitimate business activity standing alone, so that it does encompass employees. It does encompass businesses in a very, very broad way, Mr. Chairman. And at the appropriate time, I would like to speak to paragraph D, which we've not debated, Mr. Chairman.
Ms. Price.
Thank you, Mr. Chairman. Just for a complete understanding of where all these things are going to be placed once it's done, does computer trespass subsection, I believe it is B, still exist, and the unauthorized computer access within that, or is it a separate and there's read numbers?
It would be, this new subsection will be B.1. So subsection B will remain intact. All the other provisions of 16-9-93 will remain intact. We're just adding this new subsection B1.
So it's still under computer trespass?
No, ma'am. It'll be a new separate crime called unauthorized computer access that will be different from computer trespass.
Okay, so the H where we're changing the criminal penalties is not going to be H anymore?
Yes,
It
yes.
will be H?
Yeah.
Gotcha. Okay, thank you.
Well, in glancing at this, it kind of helps to answer the other question that Representative Bodie had. If you look at existing computer trespass, that does have the requirement that gets at if you go on a computer system without authority with the intent of doing some other bad act, then that is caught under the existing computer trespass. So unauthorized computer access is different in the sense that it doesn't have that requirement that you have an intent to do some other specific act, or you don't have to prove an intent to do a different act other than the unauthorized access.
Mr. Bodie.
Well, Comer and Vice Chairman Reeves, I appreciate, and Chairman Sessler, I appreciate the input. What I would say, though, if we're going to be going that particular route, I don't know if this statute, I know in line 10 it says paragraph 2 of subsection H, code section 1693. I think that's the only place that we have did a relate back to this particular statute. I think for judges and prosecutors, and especially with what we refer to, Chairman Sessler, between line 12 and 14, if we had maybe some language say relate back to these particular code sections, that it will make it a little bit easier on what you were saying the differences are between this statute and the prior statute that we have, because on the OCGA 16-9-93, I've represented individuals with these type of cases, and that's a very, very broad statute in itself, and you have to really go through and look at it to see what's the difference between criminal trespass or cyber computer trespass, what's the difference between computer theft. It's a very big statute. So I think if we even can do some relate back to, it'll probably make it a lot easier on prosecutors and criminal defense attorneys to see this distinction that you mentioned earlier, Chairman Setzler.
But, I'm sorry. Well, I was gonna say that what the bill does is it plugs this language into Code Section 16-9-93. There's no reason to relate back because it's in the same code section.
It sticks it in between B and C.
Okay. I see what you said. Okay, I see what you said.
Mr. Tremmel.
Thank you, Mr. Chairman. You know, we are examining this and talking about it in the criminal context, but frankly, don't really worry about prosecutors with this as much as I worry about the implication of doing this in OCGA 16-993G, the civil aspect. I mean, I think we're just opening a door where parties who detect this just go to court, and the provisions in G under civil relief basically is a wide open litigation door, and that frankly would be the bigger concern that I would have about the chilling effect, because it's got a 4-year statute of limitations, it's got damages for lost profits. So we're talking about the standard. We've been discussing the standard in the context of a beyond reasonable doubt. But I have real trouble and heartburn with the implications of opening this door to civil court for this type of activity, just for what it's worth.
Chairman?
Mr. Setzler.
Thank you, Mr. Chairman. And Whip Coomer may have something to add. I appreciate the gentleman's question. That's why, as we looked at these exemptions, we looked at that from the standpoint of, if we're going to err, let's err in the side of broadening the exemptions. Because when we have cases, right now, there are cases we would, whether you're prosecuting or bringing a civil case, there are cases that are a country mile away from any of these exemptions that are bad actors, and we know it, and we really have nothing to bring. To the gentleman's point, it's why we wanted to have the broad exemptions. Why, from a household perspective, we broadened it. From a legitimate business activity, we broadened it. And why even, if you look at, the one change that happened in the sub on lines 18 through 19, the Cybersecurity Act of Defense Measures, the idea of a offensive countermeasure, that was taken out of this because that was seen as a way to maybe authorize somebody to do sort of a counterattack on your system that may be a little outside the bounds of what we would be wanting to set up. So I think the civil component of this was very important for crafting this. And again, to the extent this really lives in the shall not apply to, we're already in a preponderance of the evidence kind of rubric in terms of proving that you don't live there. And I think we crafted that in this substitute with that exact issue in mind. And Mr. Chairman, at the appropriate time, if there's a question about the persons who report vulnerabilities, there's a clear desire to make sure that people who would hack a system and then report to the person who they hacked, hey, we hacked your system. There was a long policy debate around why D in this support letter is just not workable, and we could address that if it pleases the chair.
Well, give us the 2-minute summary on D, and then I want to get to see if there's anyone in the audience who's got any objections to the substitute.
Mr. Chairman, just the idea that you read this, if someone were to get into someone's system and then report the vulnerabilities to the person whose system they slipped into or broke into, if that becomes a blanket exemption, that's just a blanket exemption for something. There was a lot of testimony in subcommittee around this idea of a unauthorized white hat hacker. There's a professional certification around people who do that for businesses, and the idea that someone would deem themselves worthy to hack into Allstate's system and then say, hey, Allstate, we hacked into your system, here's how we can fix it, as a blanket exemption, that was specifically addressed and debated and believed not to be part of a best practice we would want to give a blanket exemption to, Mr. Chairman. because, Mr. Chairman, if you read the way D is suggested here, an exemption that would allow you to intentionally access someone's system with knowledge that such access is without authority. An exemption to any responsibility for that is that if you did that, if you accessed a system intentionally, knowing you did not have authority to access that system, if you then, before you're caught, report the vulnerabilities to the vendor in writing, if you then do that, you're exempt from any responsibility for having hacked the system. That was debated exhaustively in subcommittee, and is specifically what we don't want to do, Mr. Chairman. I understand that the contention, there are people who claim that's a legitimate business activity, but we were very clear that by virtue of reporting what you've done, you don't get access, you're not exempt from responsibility for unlawfully accessing somebody's system. That's how D is crafted. That if I snuck into your house, as it were, I'm sorry, Mr. Chairman. I was very unclear. Forgive me. I'm referring to D and this ACLU letter that Mr. Bodie had referred to as, hey, we need to add this in as a provision. Forgive me for the lack of clarity. Yeah.
Mr. Chairman, if I may, just addressing what is subparagraph D or 2D in the bill, or the substitute committee sub, persons, it shall not apply to persons based upon violations of terms of service or user agreements. In the subcommittee discussion, there was some question raised about whether this unauthorized computer access crime would apply to people who log into somebody else's Netflix account. They get the password from the person who signed the end user agreement, but that doesn't necessarily comply with the terms of the agreement that Netflix has with the end user. So this third person comes in and accesses that service. Would they be violating the terms of this code section? And we added in subsection D to specifically say that's not the kind of activity we're trying to capture.
Thank you. I appreciate it. I see a few flashing lights. I think it's important if we have the possibility of getting to a motion before we break, I'd like to hear if there's anyone in the audience who'd like to be heard briefly in opposition to SB 315 and the substitute that we have in front of us. Yes, sir. Please let us know who you are.
Hi, my name, pardon me. My name's Chris Risley. I'm the CEO of Bastille. We're a cybersecurity company in Atlanta, based in Atlanta. We've raised $40 million in venture capital. And
let me ask you just to keep it to a few minutes,
sure.
If you could. Thank you. Sorry.
I wasn't trying to advertise the company. That's
no, that's fine. Public airwaves.
So I object to the bill, but I think the bill's going to pass. So I'd like to get more specific, particularly with respect to the last point in the ACLU letter, and that is that the bill as it's written is a if you see something, don't say something bill. And when I flew in the other night in Atlanta, there's signs at the airport that say the opposite of that. Every day, every device on the internet is getting hit by the Chinese, the Iranians, and the North Koreans a dozen times a day. What's defended us from that historically is threat research, and Atlanta's the capital of that. And threat researchers find new vulnerabilities that nobody knows to look for, and then they tell either the vulnerable parties or the vendors that can fix them, and you need to keep doing that. And if that isn't a protected activity in Atlanta, I have to move my threat researchers to the California office where that's not a prosecuted activity.
I appreciate your comments, but isn't that covered by line 17 through the legitimate business activity exemption or carve out?
Actually, some of the best threat researchers are entirely independent, and they're not actually doing it as a business activity. They're doing it as volunteers. They're really doing it so that they can make a presentation about it at DEF CON, in all honesty.
Okay, but I mean, but I go to the word, we can talk about business activity, but it's certainly legitimate. It's not as if they're acting with with the intent to threaten.
The issue
I
is.
mean, this is the white hat argument, correct?
Well, but the end argument is, a lot of this activity is gray, and I get that. But one thing is clear. You find a vulnerability, you go to the vulnerable parties and you say, I found this, you need to protect yourself from it. You don't ask for money. That ought to not be a question of trial. That ought to be, I know I'm safe in doing that.
Well, it comes down to, I mean, really, that's going to come down to, it's a fact-by-fact, case-by-case
Which
basis.
becomes a trial.
Which really becomes well, no, but that really comes down to a matter of prosecutor discretion. The last thing I think Mr. Scanalakis' people really have the time or the energy for, the desire, is to go after some white hat who clearly, in their mind, from their investigation, didn't have nefarious intent. They have better things to do than that. However, if they stumble upon that and there is nefarious intent, then they can move forward with it. But it's going to come down to what the real intention was of the person you're talking about. Isn't that correct?
Well, but you're guessing you're going to catch these guys before they come forward.
Oh, I think the vast majority won't be caught, in all honesty.
I've been in the security business 25 years. You're not going to catch anybody before they come forward. The only people you're going to catch are the people that come to you and say, sir, you've got a vulnerability. And so that says, I'd like those people to be able to say, sir, you've got a vulnerability, and not think, well, this will now be a question for priors of fact.
Call on Mr. Coomer.
My only comment, Mr. Chairman, as I said earlier, if we were plowing a new field here, I would be much more worried about these kinds of arguments. 46 states have this law on the books or something very similar, including California and New York, and states that have been doing this for years and years and are the cradles of this kind of innovation. And to come and say that if Georgia has a law just like those other 46 states, it's suddenly going to kill the industry, I just can't accept that.
All right. Thank you, sir.
Thank you.
Yes, sir.
Hi, Chairman, committee. I'm a student from Marietta. Representative Reeves, actually, I'm one of your constituents, and I'd like to go into the security research field. I'd like to offer my strong support for the amendment that was just being discussed, as well as the second amendment offered by Representative Bodie. To clarify how the security research field happens, a lot of it is done for free. At my university, individuals regularly try and expose vulnerabilities and report them to companies for free because there are malicious actors from other countries and within the United States that are regularly hacking networks, and we have no idea that they're doing that. The only way that these companies will know is if this activity is reported. This activity is not covered under legitimate business activity because it's not a business. No one is getting paid for this. This doesn't eliminate the teeth of the law, because if you access a network for a malicious reason, you obviously are not going to report it to the entity that you just hacked. This only stops reporting by Good Samaritans, and that's why this exemption would be limited enough in that it would allow good activity by Good Samaritans to continue without stopping the teeth of the law, which is to eliminate hackers who have malicious intentions. To address the point made by Representative Coomer, I don't think that this is intended to spur a bunch of activity that will lead to future criminal activity, because we can add in freely and in writing, which I think is in the letter and in the amendment offered by Representative Bodie. This stops individuals from coercing companies after they find vulnerabilities, because they have to do it for free and in writing. They're not able to say, hey, I want money for this vulnerability that I found. And this will lead to better security for all individuals in Georgia and other individuals across the country that use applications made in Georgia. I'd also like to offer support for the language that was discussed related to the legitimate business activity to protect individuals. A lot of the activity that is done in security research is from freelancers who are hired by companies and given broad mandates to uncover vulnerabilities. These individuals who are employed by these companies do not have specific mandates related to which servers or which cloud networks they can or can't access, which means that it might not be a legitimate business activity, but the employee might reasonably believe that that activity is necessary to his or her work requirement. The California law that Representative Coomer was reading, as well as the Alabama law, the Florida law, all include this exception for individuals who believe that certain access is reasonably necessary to their work. And I think that protection for employees is very key. Now, I think the sentiment that we have hope in our criminal justice system to accurately execute the law in the way that it is written and in the spirit of law is good, but at the same time, we must be aware of the chilling effect that it can have on Good Samaritans as well as employees who want to go into the security research field. I know that UGA will no longer continue to do the type of hacking and reporting of vulnerabilities for free if they believe that it is illegal because it is not covered under the legitimate business activity exemption. At the same time, I know that I as an employee would be scared to take on broad mandates by companies to look for vulnerabilities if I believe that I could be prosecuted because I'm not sure whether what I'm doing falls within a legitimate business activity.
Thank you, Mr. Chairman. There is some discussion that's being brought up about people who do this activity and don't get paid for it as opposed to people who get paid for it. I have a hard time imagining, and there's two answers here. First, I have a hard time imagining that prosecutors are going to prosecute people who are doing this without remuneration and somehow let people off who are doing it to get paid. That's a backward way of thinking to me. But that said, I believe subsection C that talks about cybersecurity defense measures designed to prevent and detect unauthorized computer access also applies to cover those people who are volunteers, who are students, who are people who are not getting paid in the process. And I'll tell you this, if I'm a prosecutor, if I'm bringing one of these cases forward as a prosecutor and somebody says, well, I didn't report it. As a prosecutor, my first line in my opening statement is this guy broke in and didn't report it. That's part of the evidence. If somebody comes forward and they say, they were discovered because they reported it, as a defense attorney, my first line is going to be, they're only here because they reported it. If they had a bad intent, they wouldn't be here. They wouldn't have reported. So I get that there are concerns that I think some people have. And I just keep going back to the same thing. 46 states have passed this law. 46 states have passed this law. This is not new.
How is it that C, and have you seen the substitute?
I have, yes.
Okay,
I'm
how
up
is
to
it
date.
that C does not cover, in your opinion?
C does not cover it because the activity that universities and Good Samaritans are doing are not just active defense measures. There are other types of access that could be used to create patches that is not within this precise term of art that is used in the industry to only cover specific activities, which is why I think an additional exemption is necessary. To address what Representative Coomer just said, I agree and I hope that prosecutors don't go after Good Samaritans, but if you are a university that sponsors this type of activity, there is no way that you are allowing your students and your professors to continue this activity when you know that by the letter of the law it is illegal, because you open yourself up to too much liability because individuals can potentially be prosecuted, which means that this activity, there would be a massive chilling effect. If you're a Good Samaritan, I understand that you can hope that a prosecutor won't go after you, but there would be a chilling effect in you reporting this, but you would have access to it. So that's my concern.
I just don't I feel your passion and your authentic sincerity. It really is, but I'm still looking at C, and a cybersecurity active defense measure seems pretty broad, that are designed to prevent and detect unauthorized computer access that doesn't necessitate a business activity. It's pretty broad, and I think you could fit a lot of different approaches into that line. and I don't see how you're specifically not included in there. I mean, I think it's in there to be purposefully broad, specifically for people like you, frankly,
And Mr. Chairman,
who I think do a great job. But let me get that response from you, and then we'll shift to Representative Setzler.
Two things. I don't want to dive too much into the
And
technical.
we can't deal in terms of art, because that
Fair.
term of art that you're talking about, that's not a defined term in the code. So I don't think.
I'm not a lawyer, but if I need to prove in a courtroom by a preponderance of evidence that what I'm doing is a cybersecurity active defense measure, there are other types of patches that, for example, fall under defensive measures. Simply accessing and reporting something is not necessarily an active defensive measure, and there are experts that would be able to testify for the prosecution, which would really impede my ability to prove beyond a reasonable doubt that I fall within this exception. I would say that I have not heard a reason for why the exception offered by the amendment, the last amendment that Representative Bodie has discussed proposing, would remove the teeth of the law. So even if you think that C might cover the activity, I think you should this committee should err on the side of protecting the industry and Good Samaritans and researchers that are doing valuable work that protects Georgians every single day. We should err on the side of protecting those, because the amendment offered does not prohibit stopping bad activity in any way. It does not remove the teeth of the legislation. It just ensures that this activity and the industry that relies on this activity is protected within the state.
Okay, let me give Mr. Setzler the ability to respond to that as a
Sure.
subcommittee chair on the issue, and then we'll go from there.
Appreciate your coming today. I don't want to be rude or coarse in any way. I'm also trying to, I think this committee also tries to do a job of separating out the passion with which one speak, which you clearly have, to the language on the page we're voting on. The reason active defense measures is in this is if it were simply defense measures, it might be construed to be simply a firewall or something that is a purely defensive activity. The reason cybersecurity active defense measures are in, because in active defense, there's activity involved in said defense. And it's qualified by that are designed to prevent or detect, but prevent unauthorized computer access. So the measure that's part of a cybersecurity active defense is not just a firewall and password, okay?
Sure.
It's active measures to include a system of people, perhaps, that are engaged in this active activity, not a passive activity, but an active activity of providing cyber defense. That's why the chair's point that subparagraph C may not give you this blanket carve out that you're desiring that says, if people do what I do, they're exempt. We're not looking to do that. We're looking to write good law that's broader perhaps than what you're looking for but there's a line of about 20 entities that have come before you that said, we want our carve out. And what we've done very carefully here is to try to accommodate every single interest that came to us, yours included, not just with protection about legitimate business activity, but with this issue of cybersecurity active defense measures, because activity, cyber defense is broader than just a firewall or a password gate, as long as it's furthering the prevention of unauthorized computer access, which is what you're saying. Okay? So that's the chairman's point, that this is designed for a number of activities, a business doing it, or perhaps, as you might say, a whole system of people that are engaged in this. And it's not you don't have to prove in court beyond a reasonable doubt. You do not have to prove in court beyond a reasonable doubt that this applies to you. It is a preponderance of the evidence standard, which is one of those reasons we created these very broad. It doesn't have your term of art listed in a list of 20 things, because when you list 20 things, the exclusion from that list creates an inference that it doesn't apply to you. We wanted to create it very broadly. So I appreciate your passion, but this was crafted specifically to address those kinds of issues. And I'm not going to tell you to trust me, but I do want to tell you that your concerns have been addressed and have been intentionally included in the language you see here. So I just wanted to share that with the gentleman, also members of this full committee.
I very much appreciate the work that your subcommittee has done and this committee has done in general to make sure that the language is right. But to reiterate the concern with the language, you brought up an example of a firewall. if a researcher from my university found a vulnerability in a firewall, and that is a defensive cyber measure that is used to stop intrusions, it is not active. I personally, and I feel that members of the committee might feel the same way, would want that vulnerability in the firewall reported so that that vendor or that vulnerable party can patch that vulnerability so that other malicious actors from other countries or criminals who might take advantage of that firewall vulnerability will not use it. And I will also make the additional point that all of this research is done in conjunction. So even if cyber or active cyber measures are protected, if we stop defensive cyber measures or other legitimate activity, then individuals that are doing both types of research will cease doing research altogether. Finally, while we've been discussing that amendment,
We're not going to cross-examine you on your assertions. We're not in a place to challenge you. You make a statement that's unexamined, that all these things will stop. The chair's not in a position to cross-examine your points. I would just ask you to be measured in what you say, because we're not going to cross-examine everything you say. We don't have time for that, but we could. I just want to make that point, Mr. Chairman.
Let me give Mr. Coomer one moment, and then I know there's someone else who wants to be heard.
I need to, but I'm listening to what he says as well.
Okay, do you want to be heard, sir?
Yes, sir.
Okay, so Representative Coomer is going to have a word, then I'm going to call on this potential witness, and then we'll announce our next move on it.
Thank you, Mr. Chairman. And I do know the next witness is, I believe he works at Georgia Tech, so this is particularly relevant. I'm happy to report that the university system supports the bill as written. They have no objection, they have no concern that's been expressed that this bill is going to quell legitimate business or academic activities either. So to that point, and more broadly, well, I'll just say that. That's all I'm going to say for now, Mr. Chairman.
Okay, thank you very much.
yeah, thank you very much.
Certainly recognize you. Just let us know who you are and who you represent, if anyone, and just take a
Perfect.
few minutes if you could.
Yes, sir.
Thank you.
Mr. Chairman, Subcommittee Chairman Sessler, I appreciate all the time you've given me at the previous hearings. My name is Frank Rieta. I own my own company that does active development to prevent data breaches. My background was 10 years ago, I graduated from Georgia Tech with a master's in information security. While I don't work for them, I certainly claim them as where I'm from, an alumni. I'm just now looking at some of this language, but still, I have to say that I would support the recommended amendment to add those who report freely and in writing as an exemption. Cybersecurity research, threat research, is not an extortionist event. It is a careful balance that has been developed by our industry that recognizes that those who find out that they have a vulnerability are unlikely, for various reasons, to fix it. So they are incentivized because of money. You know, the developers are no longer working on that project. It's just in deployment. So sometimes the only thing that brings a vulnerable party to action is the daylight of public disclosure as a last resort. And the best researchers will attempt to bring this to the attention of those who can fix it privately and in writing with sufficient time for it to be corrected. And under this law, unless they are a subcontractor for a pen test engagement, it is not clear that legitimate business activity to a non-attorney who is educated and wants to be in this business, that they can even conduct these acts. As written, you will never, unfortunately, as much as I love the state of Georgia's criminal justice system, I doubt we will ever see a member of the Chinese intelligence or Russian intelligence who've executed advanced persistent threats on networks be brought to justice in the state. They are separated by oceans and legal systems and other parties. But what you will do is the gentleman Craig Young, who was here yesterday, could not come today, who went to Georgia Tech, works here in Georgia, lives up in Johns Creek, has a wife and family, does threat research for Tripwire, and based on his experience, every website he visits, and by the way, visiting a website is accessing a computer system. Your phone sends an IP packet across the network, across multiple networks, that is processed by that computer when you get the results back. That is an access of a computer system in the technical terminology. So a prosecutor certainly could say that visiting a public website is accessing a computer network under this statute, as I read it as someone who does cybersecurity policy, though I'm not an attorney. So what this brings us to is that in Georgia, you have to get permission before you visit a public website. Because if they come back and say that you weren't authorized to do that, you went to a page that wasn't linked off of the home page, you changed HTTPS into HTTP, which from the public reading of the Kennesaw State University incident is what happened. This private data was indexed by Google. A legitimate threat researcher, not in his day job, tried to do the best thing to bring it to the attention of those who could fix it. But for their own purposes, again, this is from the public, I have no information. For their own purposes, they ignored it. So then he goes to Georgia Tech and attempts to go through Georgia Tech to say, hey, do you know someone at KSU who can bring this to the attention of those who can correct this? And that fell flat. So then ultimately what happens is the state attempted to prosecute him for hacking. And the state attorney general's office and the FBI both said, no crime that we can prosecute. That's why we're here today. So if this can't be interpreted to prosecute under those facts, then I don't see why this law needs to exist. Because it's already a crime to extort. That could be prosecuted in a current law. It's already a crime to install malware and to exercise advanced persistent threats against the network. So if you had someone in Georgia, they could already be prosecuted. This misdemeanor crime will, in my view, will only be used for two things. To prosecute people like the KSU incident, which is obviously the stated case, to prosecute people like Craig Young, who couldn't be here today because of work, who everywhere he goes, he sees vulnerabilities. At the Homeowners Association website, they have a coding mishap, and that's a low value thing. But this is not someone who's sneaking into the network and lying in wait. This is someone who knows HTML, knows the internet protocols, sees the URL structure that things that normal people don't see, and says, hey, there's a problem and you should fix it. And when he comes forward and says, hey, I was at your website, I noticed this problem, this is a chilling effect because he's going to reasonably feel that he could be prosecuted, risk his family's livelihood if accusations were, and in another extreme, if accusations were made, he could lose his job, he could never have a security clearance. This is an absolute shutdown of that sort of research. And the other fear I have is that for criminal justice, there may be a case where a defendant may be accused, maybe the evidence is there to go looking, but who knows if they actually committed the bigger crime. So the prosecutor gets their warrants to go after, to investigate their computers and computer systems. They have this long list of charges against them. They have a family. They have a job. They're said, you know what? If you take this plea to this unauthorized access, this will all go away with a fine. But then they have a criminal conviction. They can never get a security clearance again. They have significant career disruption, all because they tried to bring information to a company that thought it would be better to involve law enforcement to fix the fundamental vulnerabilities. And if I may, one last point. When I go to security conferences in the industry right now, one of the hottest topics is cybersecurity insurance. Literally, how do we buy a security insurance policy that pays us when our customers' data is stolen through a vulnerability, rather than how do we do the best possible defense and countermeasures to reduce the likelihood of that happening? They want to buy insurance more than they want to fix fundamental vulnerabilities. And for companies like that, responsible disclosure is the only thing that will make them fix a problem rather than sweeping it under the rug.
Thank you very much for your testimony. I appreciate what you're saying. I can tell you in all honesty, doing nothing is not an option. Doing nothing is not an option. 46 other states have acted. We will act. The question is striking the proper balance in order to assure to the best of our ability that unintentional actors and actions don't get caught up. Part of that is always going to be a part of prosecutorial discretion. That's our criminal justice system. Part of that, a subset of that really is faith to a certain extent. But we do have the example of other states. Some are stronger, some are weaker. The intent that we have is to go ahead and to strike that balance. This is the type of thing, the type of law that I sense it will be enacted to some, in some version. My sense is that as technology progresses, as certain industries progress, your industry didn't exist X number of years ago. Now it does. There'll be offshoots of that industry over the course of the next generation that we can't possibly foresee right now. But it'll occur, and the law will go ahead and evolve with that. We're frankly behind as it relates to this particular area. So we're going to act, but we're going to try to act in the context of a very balanced manner. I sense I know that that's the Attorney General's intent in bringing this legislation forward through Senator Thompson and Representative Coomer, and that's going to be, that is our MO in this, and that's how we're going to try to act, or that's how we're going to try to approach it as best we can. So I just want to be upfront about that. To the committee, what we're going to do is hold the bill until Thursday morning. This committee is going to act on Thursday morning. We're going to meet from 10 until 12, just like we have today. Let me ask anyone who has a proposed amendment to go ahead and have it printed. Have it printed, and to the extent that it can be distributed electronically to members prior to the meeting, that would be helpful. But at the very least, it needs to be printed and in the folder before we convene on Thursday. We'll go ahead and have probably some brief discussion, but we'll more than likely move to a motion sooner rather than later. We'll have seen the amendments at that point, and we'll go ahead and act on the bill as well as any amendments that are proposed by members of the committee. I want to thank the committee for their attendance this morning. The plan is to not meet on Wednesday. Thank you, and we're adjourned.